At our firm, we represent the injured harbor workers in these 905B vessel negligence claims. An injured worker who suffers an on-the-job injury typically falls into one of three statutory compensatory schemes. On the one end of the spectrum, we have the Jones Act for maritime workers that spend the majority of their time at sea. On the other end of the spectrum, we have shoreside workers. In Washington, we call it L&I, or workers' compensation, that provides no-fault benefits for the injured shoreside worker. And that's usually 60% of their wages and the medical treatment to treat the illness or injury that was suffered on the job. In between these two extremes, we have the Longshore and Harbor Workers' Compensation Act. This applies to maritime workers who spend their time working on and around vessels, but don't owe their allegiance to any particular vessel or fleet of vessels. In order to qualify under the Longshore Act, the injured maritime worker must establish both situs and status. Situs analyzes where the injury occurred. Did it occur on navigable waters or nearby? And this can often be aboard a vessel, on a dock, wharf, or in the shipyard close by the shore's edge. Status is the second prong. The maritime worker's work must contribute to maritime commerce. Ship repairers, ship cleaners, longshoremen, and other categories of maritime work that are enumerated in the Longshore and Harbor Workers' Compensation Act. Shipyards can be busy places with workers and contractors from many different employers. And if an injury occurs, the shipyard worker may seek the automatic comp benefits under the Longshore Act from their employer. And like the vessel negligence claim, if their harm, their injury, was occasioned by the negligence of one of these third parties. A third party is someone outside of the employee-employer relationship. Perhaps it's someone else working at the shipyard. The injured maritime worker in that situation will have a third-party negligence claim that will run against the tortfeasor, or the person that caused the harm to the shipyard worker. We call those third-party negligence claims. And we will pursue those at our firm on behalf of injured maritime workers.